Why did you now argue all along if you are now saying this matter will be argued in the fullness of time when the pleadings are closed? Because that is what I've been trying to impress upon you from the beginning, from the first time that you stood up to try and argue this matter. Because even on your own argument, sir, on your own argument, if you, firstly, I told you the last time around, if anything, these papers before me are not proper. At the time, these papers were not served properly on all the respondents. 1. 2. No days were mentioned to them as to when they should answer to your papers. 3. The people that you have cited, I mean the state, it's the first time that I see the state is cited as an entity. Then, because there are certain members of the executive who are responsible for certain state actions. Then, sir, your application, for an example, and maybe I should read it to you, so that you start thinking about your application, and maybe, if so advised, look properly at it and see whether it deals with Section 35 rights exclusively. Paragraph 1, you say, of your notice of motion, declaring the conduct of the second and third respondents in refusing applicant meaningful consultation in preparation of his matter to be unconstitutional and invalid. Paragraph 2, declaring the conduct of the second and third respondents in refusing the applicant's request to use a laptop, tablet, or any suitable gadget in preparation of his case to be unconstitutional and invalid. Then, declaring the conduct of the second and third respondents in refusing to make reasonable provision or accommodation for the applicant to consult in person with his legal representative to be unconstitutional and invalid. For the duration and in preparation of his criminal case, directing the second and third respondents to afford the applicant the following: an in-person consultation, allow the applicant to use a tablet or a laptop or any suitable gadget. Declaring the conduct of the second and third respondents in keeping the applicant in solitary confinement for 23 hours a day to be unconstitutional and invalid. Declaring the second and third respondents to remove the applicant from solitary confinement and keep him in a normal cell. Declaring the conduct of the second and third respondents in bringing the applicant to attend his criminal case hand and leg cuffed to be unconstitutional and invalid. Directing the first and second respondents to desist from hand and leg cuffing the respondent whilst in court. Directing the conduct of the first, second, and or third respondent in bringing the applicant to attend his case in violation of Section 9, 10, 12 of the Constitution to be unconstitutional and invalid. Pending the determination of the above prayers, the plea trial be set down for the 24th of July, which has come and gone. Further alternative, and pending the determination of the above, prayers 4 and 6 and 8 in the notice of application apply forthwith as an interim order. The first and second respondents be ordered to pay the cost of this application on an attorney and client scale for counsel so employed. Then, in the affidavit itself, you say that you've made out a case for an interdict. Firstly, and I will read it to you, you say, I'm advised that your client, in order for the application to succeed regarding the final and or interim relief, that I am seeking the application as to meet the following requirements: that I have a clear right that is worthy of protection for a final interdict and a prima facie right, even though open to some doubt, for an interim relief. Now, it's not even clear whether you're asking interim relief or final relief. Then you say that there's a reasonable apprehension of harm, or harm has actually occurred. that the balance of convenience favors the granting of an interim relief. Can you see what I'm talking about? Now, I'm saying to you, Mr. Moyla, that I'm not going to enter into a debate with you about this issue again. I'm saying to you that your prayers, firstly, are civil prayers, and secondly, they stray far beyond the Section 35 rights. Now, you file your replying affidavit, and you act in terms of the rules of this court, and this matter will then be set down. A judge will hear the matter, and the judge will then decide. If you want to argue to the judge that the matter must be postponed, he must make, or she must make a ruling that your client must be there at that stage when you make your arguments, you are welcome to do so. I am not going to entertain an argument now on this half-baked application. Complete the application, complete all the papers, do what you must do in terms of the law, and then you can come back to me. All right? No, you may not speak. You have a legal representative. Yes. You can hear what he has to say. Pardon? You say?
I'm saying that I'm giving you an opportunity to write instruction, and I'm
yes.
giving your lordship so to understand, because this is the person that is suffering. So when he sees this engagement, obviously is triggered. So I'm asking your lordship to at least.
No, there's no problem with that, but I will not allow him to speak, yes, because you are here to speak on his behalf.
That is correct, my lord.
Yes.
But I don't want to go back and forth on this. The issue here, the only issue here, is when the presiding officer purport to make ex parte comments and purport to prejudge the application and not allow the practitioner to comment.
The application will be ventilated in front of another judge at the opportune time, sir. Then you can ventilate all these issues. Mine is to get this matter trial ready. That's my task. If you want to argue all these things in front of the trial judge, you may do so.
What I'm simply saying that, my lord,
or the judge that will hear the application.
It is in any circumstance, it is unfair for a presiding officer to make ex parte comments prejudging the matter and not give the practitioner to comment on that. And that's why I responded to that. Your lordship.
To comment on what, sir?
Your lordship gave me a list of questions. When I was answering the first question, your lordship then interjected and not allowed.
Are you going back there now?
No, but I'm just.
What is your point, Mr. Moyla? What is your point, please? I fail to understand the point. I've been repeating myself over and over again, and you've also said you'll ventilate this point at the opportune time. Now, this is not yet the opportune time. That is how simple this whole issue is.
Can I make the point that your lordship has asked? Because your lordship has asked what is your point, Mr. Moyla? The point that I'm making. When I stood up, your lordship gave me a list of questions. Address this, address that. On top of that, your lordship made comments about our application. In addressing those questions, I brought to the court's attention that actually what this court says is opposite to what our papers say.
But then I've read the papers. Yes.
Then my learned colleague then responded. Then I said, in that circumstance of his sensible suggestion, there's no need to say anything further, because he didn't say anything that is worthy of responding, because he didn't invite me. But when your lordships make comments and invite me, I'm happy to respond.
But sir, you said to me, you brought your paper. The things that I have said to you are selective. I've read your entire application or prayers to you. And I'm saying to you, like I said earlier, they stray, in my view, beyond your Section 35 rights. And I do not want to enter into a further debate with you. Make sure that you file your replying affidavit. Make sure that you file your heads of argument. In terms of the rules of this court, a judge will be assigned to deal with the matter, and that judge, you can go and ventilate all these things in front of the judge. I will assign a judge to listen to your entire argument, even on the jurisdiction issue. Everything that you want to ventilate, that judge will hear when the papers are ripe, sir. That's the only point. The papers are just not ripe.
That point is accepted.
Precisely. Now, if that point is accepted, I expect you then to sit down. And yes, then the matter is over. You took an instruction from your client. Is it relevant? Do you want to ventilate that instruction or not?
Yes, my Lord, his concern obviously is the concern that I'm trying to place here. So, and it stems from the comment that if your Lordship has said that this application is not right,
I've said that from the beginning, Mr. Moelo.
it was preceded by expert comment, my Lord. The record will show that that was not the only, it was preceded by people commenting on the...
Mr. Moelo, I have said that. You either now deal with the instruction from your client, or you will file your replying affidavit, and this matter will be dealt with in terms of the rules of this court. A judge will be assigned to listen to your argument.
That it will be ventilated
In that, yes.
there's no need to proceed with
Precisely. No need at all.